So welcome to this Partners in Care webinar. We're doing the webinar today as part of our National Safeguarding Adults Week events for 2023. And I'm really pleased on behalf of Partners in Care to be able to introduce Dr. Laura Pritchard-Jones, who is the Programme Director for the Masters in Safeguarding Adults at Keele University. And Laura's here today to talk about human rights approach to adult safeguarding. Over to you, Laura.
Thanks very much, Karen. Just checking you can hear me and see the slides okay.
Yes.
Brilliant, lovely. That's one set of technical glitches that hopefully we won't have then. So yeah, afternoon everybody. Lovely to see you all and to meet you all virtually. I'm really pleased to be able to support Partners in Care by hosting this webinar. Partners in Care is an organisation that we work really closely with at the School of Law at Keele. And so whenever I get the opportunity to hopefully support them, I try and do that. So I'm going to talk to you a little bit today about a human rights approach to adult safeguarding. So in terms of what I'm planning to cover, I'm going to talk a little bit about what human rights are, basically. So I'm sure we've all got our own understanding of what the term human rights means. Obviously, as Karen said, I'm in the School of Law, so I come at this from very much a sort of legal angle and legal mindset. So I'm going to kind of demystify this legal concept of human rights and show how it might apply to the various organisations that you might work for. I'm also basically going to give you a little bit of a brief history of human rights time, so where they came from, and because I think that always helps to inform our current understandings of human rights and how they apply and how they work in practice. I'm going to look a little bit at when human rights apply and also why we need an understanding of human rights for adult safeguarding. So what does it mean in practice for you in your various different roles? And I'm aware that some of you might be coming at this more from a frontline perspective, and some of you might be coming at it more from a strategic or a managerial perspective. And human rights as a legal concept, but also as a practice concept, have relevance regardless of really which angle that you're coming at this from, or that you're attending, which role you're attending the training today in. And then lastly, thinking about how an understanding of human rights can inform practice in adult safeguarding. And so what I usually do with any sorts of sessions like these is try and operationalise some of the more legal stuff that I'm going to be talking about earlier on in practice through a series of case studies. And I've got a couple of case studies that are lined up a bit later on. What I'm going to do is I'm just going to minimise that so I can actually see the full extent of my slides myself. Fab. So, I want you to take just a second to reflect on what you understand by human rights. You can feel free to put a comment in the chat if you want, or feel free to say something if you want to. Again, like Karen said, obviously bearing in mind that if you're saying something that it's going to be on the recording. But what it is that you understand by human rights. We all know this term. We've probably all heard this term, certainly in a professional context, but maybe even also in a personal context. So what is it that you understand by human rights? I'll leave that as an open question for now. And then we might be able to revisit it a bit later on in the presentation or in the talk, just to see actually to what extent the understanding that you had about human rights actually aligns with a lot of the stuff that I might be talking about later on. So in terms of thinking about how human rights apply in the context of adult safeguarding practice, this is really, so this is an extract taken from Kate Spreadbury and Rachel Hubbard's book, The Adult Safeguarding Practice Handbook, and they neatly summarise really the role that human rights play in the context of adult safeguarding. So on the one hand, we have the very sort of doctrinal legal framework that human rights exists in, that kind of provides the structure around which other laws have to operate, but also professionals implementing those laws also have to operate as well. It outlines some of the definitions of what human rights are, what rights are actually protected, what those duties and responsibilities are, and a template for action as well in terms of upholding and protecting those rights. But then beyond that, adult safeguarding as a practice obviously relies on a particular perspective and an approach to that practice. And so the second point that they mention is that human rights can actually operate as a perspective. So upholding rights and all the concepts that underpin rights like dignity can operate as an effective perspective that might inform our approach to adult safeguarding practice, and it might inform our values and actions in practice. And so it's that sort of dual role for human rights that I've taken today as being the sort of framework for the rest of the talk. So I'm going to start by talking a little bit more about the legal framework and demystifying some of the legal framework around human rights. and then think about more what that can tell us about human rights as a perspective that informs our values in the sectors and in the context in which you're working. So in terms of the history, I think it's important for us to understand the modern day legal protections through understanding a little bit more about where they come from historically. And interestingly, as some of you may already know, particularly I have a particular fascination with World War I and World War II in terms of reading about the history of it. And that's exactly where our modern day human rights protections in law stem from. If any of you are interested in reading a little bit more about the origins of this, then these two screenshots on the left of a couple of books that are really, really fascinating. So the first, Into the Dark, is a book that's written about, in particular, the persecution of disabled people and the various programs that the Nazi Party had on in relation to to disabled adults and children. And then also Justice at Nuremberg is about the lead prosecutor at the Nuremberg trials. He was a physician of the day, and he talks about some of the ethics in practice around some of the medical research that went on, and the unethical medical research that went on. So it's unsurprising that the European Convention on Human Rights is therefore grounded in some of those atrocities that we now know as having taken place during World War II. And the reason I talk first about the European Convention on Human Rights is because that's where our modern day human rights are protected. Those ones that are actually legally enforceable, that can be legally upheld, and that, as, for example, bodies working in this area or organisations working in this area, this is what governs a lot of what we have to do, particularly if you are public bodies. So the European Convention is the starting point because it's the origins of where our legal protections exist today. And this convention was drafted in the 50s, and it built on the existing sort of universal declaration that happened globally as part of the UN. And the UK was one of the original signatories, which entered into force into 1953 in the UK. That didn't necessarily mean that we could argue breaches of these rights before the courts. We had to go directly to the European Court of Human Rights in order to do that back then. It was, and this is why the Human Rights Act is important, it was only after the Human Rights Act 1998 came into force that we could actually directly argue breaches of our rights before the domestic courts. But most importantly, I suppose, is this idea that the European Convention is a living instrument. And so the rights that are protected are also living instruments, and they must be interpreted in light of present day conditions and present day values. So one very concrete example of this is, originally something like corporal punishment wasn't necessarily seen as a violation of rights, whereas now it is. So human rights are in some senses shifting goalposts, legally speaking. And the European Convention on Human Rights and all the rights that it protects, which I'm going to talk about a little bit shortly, are also living instruments, and the way that they have to be interpreted shifts over time. I'm going to look at one in particular that we probably mostly will be familiar with, and the way that definition of the right, or the protection of the right to liberty, has shifted over time through the Cheshire West case. Some of you will already be familiar with the Cheshire West case. I'm going to talk about that a little bit later on as well, to kind of show how what we mean by this as a living instrument. So in terms of some of the key articles that are protected by the European Convention on Human Rights, these are the primary ones. I've highlighted there in bold some of the ones that are most often referred to, particularly in the types of settings and sectors that you may work from in your professional lives. So Article 2, the right to life, this is protected by Article 2. Article 3, the right to be free from inhuman and degrading treatment and torture. Article 4, the prohibition of slavery. Article 5, the right to liberty. This is a huge one currently in terms of the Declaration of Liberty safeguards, because the Declaration of Liberty safeguards are grounded in this right that's protected by Article 5. Article 6, the right to a fair trial. Article 8, the right to a private and family life, and this is again a very, very broad one that encompasses most of what we might do in our professional lives in anything related to, for example, healthcare or social care. Article 9, the freedom of thought, conscience and religion. Article 10, the freedom of expression, and Article 14, the prohibition of discrimination. And the prohibition of discrimination is not a standalone right in the same way as the rest of these on the slide are, but it's one that's contingent on one of these other rights being operated as well. So what do rights mean in practice then? So it's commonly said that there's positive and negative obligations that stem from human rights. So the right to have our life protected, for example, is the example of a positive right. That might be, for example, to have protective mechanisms put in place around which our lives can be safeguarded. So the positive obligation is, generally speaking, the right to have something done. And a couple of case examples from the European Court to exemplify this. So in Dodov in Bulgaria, this was in relation to an older woman who died in a care setting. And the European Court of Human Rights said that there's a positive obligation to properly investigate the death of a person in the care of the state. And it was only with that positive obligation in place that that state could properly uphold a person's Article 2 rights, the right to life. Again, in TM and Moldova, the court said the same, but in relation to domestic violence. And there has to be properly effective mechanisms by which we can investigate and respond to domestic violence or allegations of domestic violence through the criminal law, for example, which was the subject in question in this case, properly to uphold the person's Article 3 rights, so the right to be free from inhuman, degrading treatment and torture. These are the positive obligations, so the right to have something done, and they typically are framed around the right to have a proper investigation where there's an alleged breach of a particular right. On the other side, though, rights also come with them with negative obligations. So that's typically framed as the right not to have something done to you. This is probably the more common one that we might encounter. And again, a couple of examples here. So in Moselle in France, this was about a prisoner who had been handcuffed and kept in inappropriate conditions en route to a chemotherapy session. And the court held that this was a violation of his Article 3 rights, the right to be free from inhuman, degrading treatment and torture. So that was the court effectively saying that there was an obligation on the state of France not to do that to him, hence why it's a negative obligation. And it's the same with Hennaf in France as well. So shackling the legs of a 70-year-old to a hospital bed the night before an operation, even though he was not at risk of absconding, this again was a violation of Article 3, in the same way as the being handcuffed and kept in inappropriate conditions were in Moselle in France. So again, this was the court saying, actually, this person has this right not to have this done to them, not to have this kind of treatment, because this would be a violation of their Article 3 rights. So the European Convention is the starting point, and it's the important starting point around where our current legal protections around human rights come from today. But the second step in understanding that is the Human Rights Act 1998. And this is probably a piece of legislation that we've all heard and we're all possibly more familiar with. But the Human Rights Act is important because it's basically what brought those rights that are protected in the European Convention into direct force in the UK. And I'll explore more in the following slides as to why it's important from a pragmatic perspective as professionals working in this sector. So it entered into force in October 2000, and it basically brought the European Convention into direct effect in the United Kingdom. And so what that means is basically people could argue a violation of their rights before our domestic courts, which they couldn't do previously until 2000. A lot of people think that the Human Rights Act actually contains the rights itself, so that the rights are contained in the Human Rights Act. That's incorrect. The rights that are protected by the Human Rights Act are the ones that are contained in the European Convention on Human Rights, those ones that I've just outlined. But importantly, for adult safeguarding, the Human Rights Act and the protections that it guaranteed now on a domestic setting had immediate traction in adult safeguarding, because the protection of rights and the categorisation of abuse and neglect as a violation of a person's rights was front and centre in those two early formal policy guidance documents around adult safeguarding in 2000. So some of you may remember No Secrets, which was the formal policy guidance in England that was issued by the then Department of Health, which is obviously now the Department of Health and Social Care. And also by the Welsh Government in Safe Hands, which was the sort of the Welsh counterpart over the border in Wales. And they both called abuse as a violation of a person's human and civil rights by any other person or persons. So you can see sort of front and centre that this rhetoric around rights and these protections that we now had in a domestic context under the Human Rights Act actually had huge traction immediately in terms of adult safeguarding, because the very first formal policy guidance that we had in No Secrets and in Safe Hands put rights front and centre and called abuse and neglect a violation of a person's human and civil rights. So the Human Rights Act and rights protections are of central importance, really, for anyone working in this area, because they provide that framework within which professionals operate in this context. The Human Rights Act legally has a dual role. So first of all, it places an obligation by which our laws in this country, including those laws that we know and we work with on a daily basis in adult safeguarding, things like the Criminal Law, Mental Capacity Act, the Mental Health Act, they have to be in accordance with those rights contained in the European Convention. But also, it places an obligation on public bodies, I'll talk more about what's classed as a public body, to act in a manner that is compliant with those rights contained in the European Convention. And as I said earlier, it also allows individuals to challenge conduct that isn't rights compliant before the UK courts. And I've got a couple of examples a bit later on as to how people have done that and the cases that have arisen from those challenges. So I'm going to start a little bit with number one. And I'm going to talk to you a little bit about the context of the Cheshire West case, which again, some of you may be familiar with. The Cheshire West case was really about depriving someone of their liberty in a community or a social care setting, and what the concept of deprivation of liberty meant. So before I get onto that a little bit later on, I'm going to talk to you more about the technical legal provisions in the Human Rights Act. So first of all, in section 2, in deciding any cases, so when something goes to court, the court must take into consideration any judgment of the European Court of Human Rights. The European Court of Human Rights was the sort of court that was set up in the 1950s to deal with any challenges to rights under the European Convention. So it's a Europe-wide court. Section 3, legislation must be compatible with convention rights. So for any of you who've read the technicalities of law, if you actually look up any statute on the legislation.gov.uk web pages, you'll see that at the beginning of any statute, anything like the Mental Capacity Act or the Domestic Abuse Act, for example, there's always a statement at the beginning, which is that the Member of Parliament or whichever Secretary of State is responsible for setting up that legislation declares that it's compatible with European Convention rights. So to talk a little bit more about this Cheshire West case, this is really one of the cases which had to grapple with what it meant to interpret our domestic laws in a way that was compliant with the rights guaranteed by the European Convention. So the Cheshire West case involved 3 individuals. So first of all was Mr. P, and this was a gentleman with cerebral palsy. He also had Down syndrome, and he was living in a staffed bungalow under quite restrictive conditions. But he did have help to leave the house whenever he chose. He was also, unfortunately, had a tendency, he had to wear a onesie because he had a tendency to, particularly when he got particularly stressed, to try and eat his incontinence pads that he was wearing on a regular basis. There was also 2 sisters. This was a case that involved 3 different individuals. It was only the 2 sisters that were related to each other directly. Mr. P, the case was joined together with that of the sisters because it grappled with fundamentally the same sorts of issues legally. So this related to second case related to MIG and MEG. So MIG was an 18-year-old woman with a learning disability, and she was living in the community with a foster mother, and it was said that she was absolutely devoted to her foster mother. She would never really try and leave the house. But the crucial point was that if they did try and leave the house, or if she did try and leave the house, then she would be brought back because she had very intensive support needs, particularly when she was out and about in the community. MEG was her 17-year-old sister, and again, living in a facility, so not necessarily a foster care home, but living in a residential facility for young people with particularly complex needs, but again, had a very active social life, much like her sister, much like Mr. P. But the issue for the court to grapple with in this case was whether these 3 individuals were deprived of their liberty. And the reasons for this is because we have, as some of you will know, the deprivation of liberty safeguards, which accompany the Mental Capacity Act. And they dictate basically the legal process that has to be gone through where there's the risk that somebody in these situations, for example, is deprived of their liberty. So the question was whether Mr. P, MIG and MEG were deprived of their liberty. And if so, then the safeguards contained in the deprivation of liberty safeguards had to kick in. So the Supreme Court, which this case eventually went to, framed it as in this way. The question is whether the concept of physical liberty protected by Article 5, Article 5 is the right to liberty in the European Convention, is the same for everybody, regardless of whether or not they are mentally or physically disabled, as they were in Mr. P's case and MIG and MEG's case. So the question that the court had to grapple with was, what is a deprivation of liberty? Are they effectively deprived of their liberty? And if so, could this be done lawfully and therefore compliant with Article 5 of the European Convention on Human Rights? So you can see how this concept of a deprivation of liberty that we might know in practice is very much grounded in the protections that are afforded by the European Convention under Article 5. And so Baroness Hale, as she then was, who subsequently retired, she became president of the Supreme Court and then retired not so long ago, said that it's axiomatic that people with disabilities, both mental and physical, have the same human rights as the rest of the human race. It may be that those rights have sometimes to be limited or restricted because of their disabilities, but the starting point should be the same as that for everybody else. And famously, the language that she used is, a gilded cage is still a cage. So although Mr. P, MIG and MEG had a very good life and they had a very active social life, ultimately, the question is still the same. Are they considered deprived of their liberty? In which case, all those safeguards that kick in order to ensure, had to kick in order to ensure that it was compliant with Article 5 of the European Convention on Human Rights. And so she formulated the test that, again, some of us may know and may work with on a daily basis, particularly if you're BIAs, or trying to work out whether somebody is deprived of their liberty, the acid test. So the acid test is whether a person is under complete supervision and control of those caring for her and is not free to leave the place where she lives. So the issue isn't necessarily to do with whether the person seems to be wanting to leave, as MIG wasn't, but on how those who support them would react if they did want to leave. So the way that this acid test is framed has had and does continue to have quite profound implications for those working in this setting. So those of you from these sorts of professional backgrounds who are here today will be familiar, if you work closely with this test, that this has profound implications for what you do on a regular basis and how you would identify whether a person is in fact deprived of their liberty. So the European Convention on Human Rights from a legal perspective is important, not only because the courts, when we're dealing with these sorts of issues, these issues that ultimately feed down into professional practice, such as yours, they have to take into consideration the rights that are guaranteed by the European Convention. And in providing a definition of a deprivation of liberty, as the Supreme Court did in Cheshire West, that definition came from Article 5 and some of the case law that the European Court of Human Rights had ultimately decided previously. The second fundamental way in which the European Convention on Human Rights and the Human Rights Act are important for professionals working in this area, perhaps possibly the most obvious one, is that it places an obligation on public bodies to act in a way that's compliant with those rights that are guaranteed in the European Convention on Human Rights. And if individuals feel that their rights haven't been upheld, or that a local authority or a public body hasn't acted in a way that's compliant with the European Convention on Human Rights, it allows those individuals to challenge that conduct before the courts on a legal basis. So again, I'm going to talk to you a little bit more about those sorts of legal protections. So Section 6 and 7 of the Human Rights Act say that it's unlawful for a public authority to act in a way which is incompatible with the European Convention right. And anyone who feels that their rights have been breached can bring proceedings to a court. So people can challenge that conduct before a court and argue that this was a violation of their rights. Public authority is defined quite expansively, and this has again been the subject of quite a bit of litigation, which I'm not going to go into in any detail here, but I will explain the basics of why this is more complicated than it looks at first glance shortly. But a public authority includes any person of whose functions are functions of a public nature. So there's obvious ones that this applies to. So public health services, NHS trusts, mental health trusts, local authorities, police, prison services, all these are those who are exercising functions of a public nature. Partly because they're publicly funded, or a lot of them are publicly funded. But care, and particularly the types of settings that you might work in, is a much more complicated and messy matter when it comes to funding and when it comes to whether something is functions of a public nature. Because you may have the intersection of private bodies, so private care homes, for example, but you might have individuals in those private care homes who are funded by a public body like a local authority. And the courts have said again, this has been the subject of quite a bit of discussion before the courts, and the courts have said again in those types of cases where you've got somebody who is having their care physically delivered by a private organisation, whether that's a domiciliary care company or a care home, but that care is funded publicly, i.e. by the local authority, either through personal budgets or direct payments, then that can be considered exercising functions of a public nature because it's arranged and paid for by a local authority. So I'm not going to say any more about that at the moment because there's quite a complex interplay between the two. But it basically suffices to say that it's not just those who might actually be a public body like a local authority, but actually these protections might also stretch to those who are working in the private sector in some circumstances. So I think it's important to outline that at the beginning. And actually what we've seen since the Human Rights Act came into force is we've seen quite a few effective challenges as to individuals arguing that a public body or an organisation exercising functions of a public nature have violated their rights in practice. So I've got a couple of examples here that are relevant for you in your professional context, because many of you will be coming from sort of the health, social care contexts. So in Essex County Council and RF, this is a case that went to the Court of Protection. The Court of Protection is the court that deals with any sort of matters or litigation that arises under the Mental Capacity Act. And in Essex County Council and RF, we had a gentleman who was 91 years old and he lived at home with his cat, Fluffy. Not the cat on the right, this is just a generic picture of a cat, but I assume it looked something a bit like this with its name being Fluffy. He had dementia, a mild to moderate degree of dementia, but he also had a number of other physical health conditions as well. He was described in the judgment as very generous, always willing to help others, make charitable donations. But there were some concerns, and a little bit frustratingly in the judgment, these aren't actually elaborated on in any great detail, about financial abuse. So because of the concerns that the local authority had about financial abuse, they undertook a few capacity assessments with RF as to his capacity to manage his property and affairs. And a variety of these capacity assessments came to the conclusion that either at various points he had capacity or at various points he lacked capacity to make these decisions. And ultimately, it culminated in a course of action by the local authority where they turned up late of an evening. He was taken to a locked dementia ward against his wishes. They turned up while he was partially undressed, so I think that he had he didn't have any pajama bottoms on. He was actually told that he was being taken to a hotel, and in fact, he was going to a locked dementia ward, and he was threatened with police intervention if he didn't comply and acquiesce to this move to a dementia ward. He stayed on that ward for 18 months against his wishes, which obviously 18 months in the life of a 91-year-old is a fairly long period of time. 18 months for anybody is a fairly long period of time, particularly when you're 91. And obviously this was away from his cat Fluffy, who he was particularly fond of. But there was evidence, and the court did find, that actually he had capacity to make decisions. He had capacity to make decisions about his residence, where he wanted to live, and about his managing his property and affairs. And so the court was very critical of the local authority's conduct on this case and said that actually this had been a violation. The way that they'd acted, particularly in the factual context of how they'd actually taken him to a dementia ward, was a violation of RF's Article 5 and Article 8 rights, so his right to liberty and his right to a private and family life, and actually awarded him quite substantial damages. And gave guidance on the level of damages if an argument comes to court and it's found successful that somebody had successfully challenged the conduct of a public body and argued that a person's right to liberty, for example, had been violated. In this case, they awarded RF £60,000. And the judge was very strong in the way that he described the local authority's conduct here. So said that actually this was reprehensible, substandard, and inexcusable, the way they'd actually gone about it. So this is quite an important one because this is in the context of the Mental Capacity Act and the way the MCA applies. I'm not going to talk at any great length about the MCA today. Obviously, it's a huge area for professionals working in this area. It's a huge piece of legislation. It's a really important piece of legislation. But this was one where the local authority really hadn't actually acted in accordance with the law. So one of the key strands that I am going to talk about later on is one of the ways in which human rights are important is because they say, and because they're open to challenge before the courts, that actually anything that's done has to be done in a way that's compliant with that legal framework. It's important to comply with those legal frameworks that we have in place that protects people's rights, like the Mental Capacity Act. The second case that I want to talk to you about is Winspear and City Hospitals Winspear against City Hospitals Sunderland NHS Foundation Trust. So this case involved Elaine Winspear on the left and Carl Winspear on the right. Carl had multiple complex disabilities and was admitted to hospital with respiratory difficulties one evening. Unfortunately, at some point overnight, without Elaine's a conversation with Elaine, who is his primary caregiver, a do not resuscitate order was placed on Carl's file. This was done under the Mental Capacity Act again, so this is a Mental Capacity Act case. Because Carl was deemed to lack capacity to make decisions about his own medical treatment. But under the Mental Capacity Act, if someone lacks capacity, then we have to, as far as reasonably practicable, have conversations with that person and take into account their wishes and feelings, and also the wishes and feelings and views of anybody engaged in caring for them. And unfortunately, the treating team that put that do not resuscitate order on Carl's file didn't do that with his mother, Elaine. At some point during the night, the do not resuscitate order was retracted, but sadly, Carl passed away the next day. So as I say, Section 4 of the Mental Capacity Act requires anybody who's making a best interest decision on behalf of a person who does lack capacity to take into consideration the views of the person themselves, the patient in this context, because they're a medical patient, or anyone engaged in caring for them. And Elaine said that actually at no point had she actually been consulted on this do not resuscitate order. And this was despite the fact that actually she'd rung a couple of times in that evening previously while Carl was in hospital to ask about his progress and his condition and how he was. So she argued that putting this do not resuscitate file on Carl's medical record, was a violation of their Article 8 rights, this right to a private and family life. And so Article 8, right to a private and family life, seems very vague, but actually encompasses things like medical treatment. That's seen as part of a private and family life. And the court said, actually, if it was practicable to have done that and actually consulted with Elaine as someone engaged in caring for Carl, but it hadn't been done, then actually putting that do not resuscitate order on Carl's file wasn't in accordance with Article 8. It was a violation of their right to a private and family life. And this judgment was quite instrumental because actually what it led to on a very practical level is updated guidance from the Resuscitation Council. Updated guidance about do not resuscitate orders in this context. So human rights actually on a very practical level have a lot of traction, and particularly in the types of settings that those of you attending today might work in, so the health setting or the social care setting. So the reason that I use this slide, and I use this slide quite often to demonstrate the way in which rights operate, we have legal frameworks that we know and we work with on a daily basis. So Mental Health Act, Mental Capacity Act, some of the criminal laws. If any of you come from a police background, you'll be familiar, obviously, with the criminal legal framework and the police powers that are at your disposal under various pieces of legislation. So, for example, the Police and Criminal Evidence Act. We know we also have the regulatory framework and things that govern things like the CQC as the independent regulator. And then we have sort of basic social care legislation that dictates when a local authority, for example, or a trust, if you're from MPFT, has to undertake needs assessments, carers assessments. And there's regulations associated with that around eligibility criteria, conducting assessments. But human rights are this umbrella that sits across all of these. This is why there's a picture of an umbrella in the background. The Human Rights Act and the European Convention is the umbrella that basically sits across all of this. So whenever we're doing anything in relation to adult safeguarding under one of these pieces of legislation, whether this is a capacity assessment under the MCA or a best interest decision under the MCA, or anything in relation to the Mental Health Act and the way in which people are being, for example, detained and assessed and treated under the Mental Health Act, this all has to be compliant with a person's rights. So in some ways, although these are legal frameworks listed here, the sort of the day-to-day of what we do, human rights also has to inform the way in which these are implemented. And so a large part of adult safeguarding and a human rights approach to adult safeguarding is making sure that when we're working with these pieces of legislation, we're doing it in the correct way, and we're doing it in a way that's also upholding a person's rights. So why should we think about a human rights approach to adult safeguarding? Well, partly because human rights is that umbrella framework under which actually all the other legislation that we work with on a day-to-day basis exists. It's the reason it does exist. If we think about the Declaration of Liberty Safeguards, the very reason that the Declaration of Liberty Safeguards exist is to ensure that there's effective mechanisms for looking at whether a person being deprived of their liberty in a care home or a hospital is lawful. And that's in relation to whether it's lawful under Article 5 of the European Convention. But also because abuse and neglect, as it was said in No Secrets and in Safe Hands back in 2000, because abuse and neglect is a violation of a person's rights as well. And as a state, as public bodies, as authorities and as organisations, we also have a positive obligation to protect against it and to investigate it properly when it does happen. And so part of this is, and I approach this obviously very much from a legal perspective, part of this does mean following those procedures and those legal frameworks in a correct way, and in a way that we can be held accountable for potentially. So for the rest of the session, I want to talk a little bit around some of the case studies that I developed to sort of really think about how human rights can potentially reframe some of the issues that we might encounter in adult safeguarding practice. So ultimately now, asking this question of whether a human rights approach can help us in identifying abuse, neglect, or identifying a response to it, and if so, how? And the reason this is important is because I have seen lately, at a more strategic national level, this drive to ensure that legal understanding, or legal literacy, if you will, around human rights is present in this particular sector. So the Joint Committee on Human Rights published a report last year around protecting human rights in care settings. And at paragraph 61, they spelled out that actually training around human rights is really, really important for those working in this sector. So specific training on human rights and its effects on the provision of services must be given by all registered providers to staff. It's crucial that training programmes go simply beyond stating what those rights are and effectively demonstrating the relevance of those rights and the use of human rights in making decisions regarding care and treatment. And the British Institute for Human Rights have also echoed this by saying that understanding human rights frameworks applicable in those care settings, so a lot of the settings that you will work in, which includes the Human Rights Act, can lead to real shifts in knowledge, confidence, and changes to rights respecting practice and policy. So in terms of practice then, the importance for human rights really is threefold, as I've sort of been alluding to all the way through. So first of all, it's about legal literacy and understanding those legal frameworks within which that we work with on a day-to-day basis, whether that be the Mental Capacity Act, the Care Act, the criminal law framework, the Mental Health Act. It's about understanding and properly implementing those. It's also about ethical literacy. So at the bottom of this page, it's also about making sure that we're understanding some of those difficult ethical decisions that might need to be taken, and particularly that face practitioners working in adult safeguarding practice. And so the perennial question is, to what extent do you promote a person's right to make their own decisions, so autonomy, versus protecting them, which is also an aspect of adult safeguarding practice. If you think about the 6 principles under the Care Act, statutory guidance, that, protection is one of those principles, but often it can be really hard in practice to think about how we protect, but at the same time also uphold the person's right to make their own decisions, that empowerment. And sometimes they can seem at odds with each other. So it's about how we navigate these sorts of ethical questions that arise in adult safeguarding practice, but also how we balance competing rights as well. So rights can often compete or work in contrast with one another. So an example that we've seen recently before the courts, a very obvious example of that, is, for example, in cases where there have been concerns about medical professionals from particular religious backgrounds who have not felt comfortable performing abortion procedures. So there's a right for a person to have their rights upheld through accessing abortions, but also practitioners have the right to the freedom of thought, conscience, and religion in undertaking their profession. So often rights can compete. And this is, I suppose, what I was saying earlier in terms of ethical literacy. Often those two competing things around autonomy and protection can seem to be in conflict with each other. So how do we balance those? So rights is not necessarily always just about upholding rights, but it's also about balancing different rights that might be in play. So the first case study, these are all fictionalized case studies. The first case study that I want to sort of raise is around potential coercion or potential self-neglect issues around to what extent Emma is able to look after her own mental health. So Emma lives with her nephew John in her 2-bedroom bungalow. She depends on John for much of her care, particularly as she has complex mental health conditions and has been in and out of hospital for many years. John's got a history of drug use, and his mum, Emma's sister, has died about 10 years ago. Emma's been known to the local adult safeguarding team for a number of years, and there'd been concerns that John had been emotionally coercive and abusive towards his aunt. This included trying to force her to transfer ownership of the bungalow to him. The police have also been called on a number of occasions after Emma's neighbours heard John shouting and loud bangs in the property. In addition to this, Emma's mental health team had noticed that during the last few visits to the property, it was in a poor state of repair. And they noticed dirty sheets on her bed and that Emma looked like she was wearing dirty clothing. Her social worker also noticed that Emma was a lot more confused and paranoid than usual and suspected that she'd not been taking her mental health medication. So I'm sure aspects of this case study, even if not these facts necessarily in exactly the format that they appear here, I'm sure a lot of this will be familiar to you if you work in an adult safeguarding context. So I want to sort of help think about the way in which rights can reframe some of the issues that we might encounter here. And so one of the questions that I always like to pose, and I'm not going to open this up necessarily for conversation now, but it'd be interesting to get your thoughts if you've got any thoughts on it later on when we have a Q&A, is the way in which human rights can help to reframe some of the issues that we might encounter or some of the situations that we might encounter through adult safeguarding and some of the cases that might come before us. So going back to some of those basic rights that are protected by the European Convention. So we've got the right to life under Article 2, Emma's right to life. The right to a private and family life under Article 8. Article 3, the right to be free from inhuman, degrading treatment and torture. And Article 5, the right to liberty. But I think sometimes the way we can perhaps best operationalise rights in practice is by thinking for us as professionals what responsibilities we have in relation to protecting these rights, because that's ultimately what the law requires of us. It requires us to take action in order to uphold the person's rights. So what responsibilities do we have in relation to these rights? And so just by outlining, again, because I approach this very much from a sort of legal perspective, one of the important things is going to be thinking through in a lot of detail, actually, what are the legal frameworks that might apply here, being aware of those legal frameworks, understanding those legal frameworks and implementing them accordingly. So, for example, there might be the Mental Capacity Act that's relevant. It might be the criminal law, particularly if there's evidence of coercion or control by Emma's nephew. Obviously, Emma is taking medication for a mental health condition. So in some way, the Mental Health Act is going to be relevant. And also there might be civil and private law powers. So it's not just necessarily those public law powers that we know and we work with on a day-to-day basis, but actually in some cases, particularly where there might be concerns about some sort of abuse or coercion, there might also be civil and private law powers that are available to Emma. And so is there any way that we could point Emma in the right direction in terms of getting advice about those sorts of powers? So a large part of human rights is thinking about what our responsibility is. And part of then working out what that responsibility is thinking about what the law says that we can and should do as professionals. So the second case study is around Dervla, who has moved into a care home in 2019, and she requires incontinence pads. Her care plan also states that she needs prompts with eating. However, Dervla is always sore because her incontinence pads are not changed as often as they should be. The care staff also often do not help her to eat, instead leaving food in front of her, and as a result, she's lost a lot of weight. Dervla is also usually found in dirty clothing, sometimes lying on her bed without anything covering her lower half, but with the door to her room open so anyone walking past can see her. In some ways, again, this helps, it might help to reframe the issues here. So again, we have the same sorts of rights that we're working with as in Emma's case, but thinking with our professional hats on what responsibilities, again, helping to reframe the issues, what responsibilities do we as from various different organisations have in relation to upholding these rights of Dervlas in this particular setting? So, of course, again, going back to what safeguarding through a human rights perspective means, legal literacy, from a structural perspective, but also ethical literacy, thinking about all the range of responses that we might need to think about in Dervla's case. So immediate responses in terms of safeguarding inquiries. So Section 42 of the Care Act obviously places an obligation on local authorities to undertake safeguarding inquiries where it thinks that there's concerns about abuse and neglect. It also requires us to understand and be better able to respond to reasons why abuse and neglect might happen in this particular context. So we're talking about the context of a care home. One of the reasons that we see very often coming through from safeguarding adults reviews into safeguarding in care homes is the need to understand more about closed cultures and the way that those sorts of neglectful conditions can take place where we have particularly closed cultures operating in care home settings. There's also clearly a role potentially for the regulator to play here as well, the Care Quality Commission. And so there's lots of different actors that are involved in upholding human rights. But this is the essence of human rights protection, that upholding a human rights approach to safeguarding is not just about one individual working in one particular organisation. It's about all of these organisations that might have a role to play in safeguarding, working effectively and working properly to think about what their responsibilities are. Ensuring care improvements and how this is linked to legal mechanisms around the deprivation of liberty safeguards. For example, Dervla might be under a deprivation of liberty safeguard at the care home in which she lives. And so what's the relationship between those deprivation of liberty safeguards and the local authority's role as the supervisory body, for example, have in relation to authorising that deprivation of liberty? There's also the operation of review, so things after, for example, abuse and neglect has emerged around strategic operations and reviews and the role that they play in adult safeguarding as well. So one example of that is the possibility for a safeguarding adults review. But also there's potentially a role for the criminal law even in this context. So aspects of the criminal law do criminalise abusive or neglectful behaviours in care settings. And so is there a role also for the criminal law to play in this particular set of circumstances? And all of these questions, so you can see from all of these questions, these aren't necessarily just down to one individual to be able to answer these, but human rights and effective human rights protections in adult safeguarding requires all agencies to be able to understand and effectively operationalise their responsibility in relation to a person's rights, rights to be free from inhuman, degrading treatment and torture, for example. Lastly, case study 3. So at the age of 19, Tom met and began a relationship with Graham, a 61-year-old man who has prior convictions for sexual offences and assault, and he moved in with him some months later. As a child, Tom was diagnosed with a learning disability which impacts his social and functional skills. In his late teens, he was provided with care and support by his local authority to support his independence in the community and was also supported and cared for by his parents throughout his childhood. Not long after meeting Graham, he moved into his flat to live with him and began to increasingly disengage from his support workers and his parents. He's repeatedly told one of his support workers, Graham, that Graham provides all the care he needs and that he doesn't need to leave the house or have any support in the community. He's also told his social worker, Jane, that although Graham is not always nice to him, he doesn't want to live without him, and that he no longer wants any input from social services or any care and support workers to visit him. So again, the last case study, thinking about how rights help to reframe the issues. So, you know, we have very much here Article 8 rights, the right to a private family life, and how do we uphold that? What are our responsibilities in relation to that, especially if Tom makes the decision that he wants to be in a relationship with Graham? And it's obviously not just that straightforward because there might be concerns around capacity, as I'll just go on to talk about on the next slide. But also actually we have responsibilities in order to protect a person from abuse and neglect, and there may well be the potential for sexual exploitation here. So this is, again, a much more complex case study in some ways, because it involves the operation of lots of different types of support services and legal frameworks that might dictate what our responsibilities are in relation to Tom and Tom's set of circumstances. So absolutely, in terms of the Care Act, those basic legal responsibilities in terms of undertaking assessments, that a person has the right to refuse an assessment, but then we still have to do one if we suspect they might lack capacity to make that, and it's in their best interest, or if they're experiencing abuse and neglect. Mental Capacity Act also may apply, particularly in terms of capacity to make decisions about contact with Graham, capacity to make decisions about sexual relationships with Graham. But there might also be aspects of the criminal law. So there's an extensive raft of criminal law mechanisms around sexual offences, not only retrospective, so things that can actually punish people in the past for having committed sexual offences, so things like the protections under the Sexual Offences Act. But there's also prospective measures under the Sexual Offences Act as well, so sexual harm prevention orders, for example. And then on the other side of things, there's all those practical steps that we might need to take before we can do anything, or alongside doing anything under those legal frameworks. So, for example, any informal advocacy services that could be put in place or might need to be put in place in relation to Tom. There's a raft of powers in relation to domestic abuse, so things under the Domestic Abuse Act, for example. And then lastly, something that you may have heard of but may not be familiar with, and I'm not going to talk at any length about it here, the inherent jurisdiction. So this is where a person doesn't necessarily lack mental capacity to make decisions under the Mental Capacity Act, so because of a disturbance in the functioning of the mind or brain, but may have been coerced or unduly influenced into making a particular decision. The courts started to sort of say, actually, we can get involved through implementing an order or direction under the inherent jurisdiction. So rights and shifting to an adult safeguarding framework through a human rights lens requires us to think about these different rights that are in play. Which rights are we thinking about? Which rights are we upholding? But also as organisations and professionals working in this sector, what responsibilities do we have in relation to those rights as well? And I think possibly that's one of the biggest ways in which human rights and a human rights approach to adult safeguarding can help inform practice, which is it poses that question of what of our responsibilities towards and in relation to upholding those rights. So ultimately, the sphere of human rights is that everybody has a role to play. So yes, there is an individual role for everybody to play working in those respective professional contexts. But it's not just about an individual has the ability to uphold single-handedly another person's rights. That it's also important for rights to be embedded at an organisation on a strategic level within the organisations as well, because an individual working in that organisation can only do so much if they've got an organisation that doesn't necessarily support them to implement and properly uphold a person's rights in whatever they're doing. But also it requires a national and governmental approach that also upholds a person's rights as well and provides a legal framework that is compliant with those rights that are guaranteed by the European Convention on Human Rights. So thank you very much for listening. I hope it's been interesting for you in some way. I just want to if you don't mind, take this opportunity just to mention a couple of the courses that we do have at Keele, like Karen mentioned. We do run an MA in Safeguarding Adults Law Policy and Practice, which is designed for professionals working in this area, if anyone's interested. We have a new MA in Advanced Social Care Law. But we also allow students to take individual modules from these programmes on a CPD basis. And these are 30 credit master's level modules. And we can also offer these on a flexible part-time and a modular way as well. So we can be really flexible to accommodate anybody working in professional practice. And lastly, if you're interested in finding out any more about that legal framework that I've been talking about, so the human rights legal framework, or any of the other legal frameworks that you might be working with on a practical basis, on a day-to-day basis, things like the Mental Capacity Act, the domestic abuse provisions, then myself and Professor Alison Brammer, who is a colleague here in the School of Law, we've written a textbook on this, Safeguarding Adults, that was published in 2019, so it's still relatively up to date. Thankfully, even more so because the liberty protection safeguards are now not coming in, because it was written, the last edition was written before we had the proposals for the LPS. If anyone's interested in finding out more about the basics of the legal framework, then feel free to buy a copy of this. It covers a range of different things. It's not just in relation to the Care Act and the MCA, but it also covers some of those private law powers as well, and as well as the public law powers that we might